South Africa's parliament has finally approved the Traditional Courts Bill. This bill now awaits the signature of the president to become law. Now, it aims to regulate the structure and the functioning of traditional courts in a more uniform way. But the Centre for Legal Integration in Africa says the new bill doesn't protect indigenous practices. Let's find out why and more information around it with UWC's Centre for Legal Integration in Africa, Anthony Diala, who joins us this morning for more details. Thank you very much for your time this morning, Anthony. Perhaps before we get into the reasons, there's a bit of uneasiness around the bill. For those of us who may not have been aware of it, please give us some context as to what the bill actually is, or the Traditional Courts Bill is, and really what it seeks to achieve within the context of South Africa.
Right, thank you very much, and good morning, viewers. The bill seeks to regulate the application of customary laws in South Africa, or rather the resolution of disputes under customary law in South Africa. And it seeks to do so in a uniform manner, in a manner that can be recognizable across all the courts, traditional courts in South Africa. Now, the bill makes provision for traditional leaders to preside over these traditional courts. But the problem is that everything that the courts will do will be subject not just to constitutional values, but also to other legislation that regulate customary law in South Africa. And another problem is that some traditional leaders, due to their impositions during apartheid and during colonialism, or the position of their ancestors, they lack legitimacy. So it's going to be very difficult to see how these courts are going to operate without eroding the freedom of people to choose other means of dispute resolution, and also giving people who do not recognize the authority of these courts the option to go elsewhere.
There's also been the argument that's been put forward as we await for that final signature to come into place, that it doesn't support indigenous practices. What do we mean when we talk about indigenous practices, and what role should the traditional court be playing in protecting those practices?
When we say that, or rather when I say that the bill does not promote indigenous practices, what I mean is that the means of dispute resolution under customary laws or in traditional settings will be quite different from the ways that these courts will operate. If we take what happens in other countries and use it as an example, we'll find that these courts are going to operate as if they are state courts. Yes, they may lack the technical rules of procedure in the high courts and the magistrate courts, but they are still going to emulate the procedures in those courts. When I point out the difficulties of not protecting indigenous practices, I do it in the broader context of the Constitution, the relationship of the Constitution with customary laws in South Africa. Now, the Constitution treats customary law as if it were an independent legal system, normative order. But in practice, that is not the case. So just to give you an example, the Constitution says that customary law and the common law should apply as if they are equal. So the courts are enjoined to apply customary law when that law is applicable, and they are also enjoined to interpret the common law and to interpret customary law in line with the spirit of the Constitution. So this gives the impression that customary law is equal to the common law. But customary law in practice is not equal to the common law, because people tend to mistake the common law as black letter law. No, the common law is accompanied by ideas, by philosophies. And so these ideas and philosophies reflect in the Constitution itself, meaning that the Constitution itself is a part of the common law. And so you cannot say that the customary law is equal to the common law when customary law is subjected to the Constitution. So that's what the article tried to point out.
Yeah, and you also highlight something which I found quite interesting, in that you question the sense or level of traditionalness, if there was such a word, of this particular bill. And you argue no, in that the way in which judgments are passed, the laws are conducted within the traditional court is mimicking Western laws. And that is very problematic, you know, because this bill is very important to protect the indigenous and traditional cultures that preside in the country.
Yeah, that's correct. Unfortunately, the extent of changes that have occurred in indigenous laws are so wide-ranging and so extensive that we cannot literally turn back the hands of time. So what should happen now is to find a way of preserving whatever is left of indigenous practices. So that's why I draw attention to the values of indigenous law, foundational values. These are the values that we try to keep a semblance of value, principles like Ubuntu, principles like preserving the family home, taking care of the family. These are the things that have to be preserved to make sure that these courts do not completely turn into Western style courts.
So with that in mind, do we have the power as South Africans or Africans in general to change this narrative that you've just described and determine our own direction within the confines of the traditional, the common law?
Indeed, and that's the essence of the article. In a nutshell, that article tries to warn, to sound a warning for South Africa to first of all identify what its legal identity is. Currently, Parliament is just implementing laws, and the effect of these laws is to force, to pigeonhole customary laws into the image of Western laws. But no one is stopping to ask to say, wait a minute, what is South Africa's legal identity? Is South Africa's legal identity customary laws, or the legal identity the Western laws that were imposed by colonialism? 100 years down the line, 50 years down the line, 20 years down the line, what's the face of law in South Africa going to look like? That's the essence of looking at all these laws that seek to regulate the application of customary laws in South Africa. I gave so many examples of them. Regulation of Customary Marriages Act, Succession, etc. It's time to look at these laws and see where they are taking us with respect to indigenous practices. Otherwise, these practices are going to disappear. The lesson from legal history from elsewhere show that if people do not take conscious steps to preserve the values of their indigenous laws, these laws will ultimately be swallowed in by imposed colonial laws.